Good evening, I'm Sanford Rubenstein, and welcome to Lawyers Corner. Tonight, once again, we talk about criminal law and what's going on in California. Our guest tonight, Frank Gangemi from the firm of Gangemi & Gangemi, and Joe DeCicco, a retired New York City detective. Welcome to Lawyers Corner, gentlemen. Let's start tonight with talking about what happened, and it was on tonight's news, 23 items of evidence with regard to blood that was on various items out in California. Prosecution's trying to introduce this evidence, will try to introduce it during the criminal trial of OJ Simpson, and the judge has delayed a ruling on whether or not he's going to let that evidence in. What do you think? Is he going to let it in?
Yes, he will. Eventually he will. I think right now he's posturing a bit. I think the bottom line here with this ruling centers around the prejudiced nature of the delay as it results or as it affects the defense. The defense, as we know, and we've seen throughout this entire 3 months of this bickering back and forth over DNA, the defense is contesting, or it believes and knows that it has a right to examine the DNA and to make its own decisions and hopefully controvert the results of the prosecution. The premise behind this whole ruling and behind the delay is whether or not
Peep is going up. That's what happens when you're a retired New York City detective.
The premise is whether or not the delay has prejudiced the defendant to the point where it has created a tremendous effect and impact on his defense and his ability to defend himself. And it has got nothing to do at this point with whether or not the DNA is in fact reasonable or statistically accurate.
Now, the delay in the defense motion to suppress the evidence, which means for our audience that the evidence wouldn't be allowed into court, right, and make it harder for the prosecution to prove their case, perhaps almost impossible. The defense is saying that the delay is almost intentional, that the prosecution is doing the test at the last minute so that the defense won't know, even during jury selection, while the jury's being selected, what's going to be evidence in the case, and that's not fair. And therefore, the judge shouldn't let it in. Is that a good argument?
It's not a good argument it's not a good argument to be the end argument and the final result of the case, or final result of the DNA. If that is in fact how the judge feels, he could always give the defense ample time to do their testing and come up with their results. I think what the bottom line here is that what the defense needs to do is to make sure that if in fact the trial is scheduled or is going to take place in the near future, that it does put the judge on notice and the judge reciprocate by letting them take DNA testing, and if he has to adjourn the trial, he adjourns the trial.
Now let's talk about DNA testing for a moment. It's something new. We haven't seen that many cases in which DNA evidence is so crucial and important in terms of what happens in the outcome of the case. What is DNA testing? What is involved here? And I know that, Frank, you have some familiarity with this because you were a medical student at one time.
Right, and I got a master's in biology and did a lot of genetic work. DNA really hasn't reared its head in the criminal case world, or caseload, I would say. I'd say maybe the last 4 years, 3 years has become relatively a strong point. It finds its basis in paternity actions.
Maybe you can explain what the testing
Absolutely.
What the testing is. What do they do in DNA testing?
DNA is your genetic material. It's the material by which every cell in our organ or every cell in our body is composed. What DNA testing does, it takes, whether it be a blood sample, a tissue sample, and it reduces that sample down to a specific genetic code. And if that specific genetic code found in the sample matches the genetic code found in the individual, the alleged perpetrator or the defendant in whatever case it may be, then there is a presumption that that individual is amongst the population that could have been at the scene of that crime, whatever that, or at the location of the incident, whatever that incident may be. It is not an exact science. It is getting better as we get along, but it still has a way to go. There still is a good amount of error in DNA testing, and that is why you have so much controversy.
So what are we going to expect on trial? The prosecution, if it's allowed into evidence, puts in the DNA evidence, and then the defense tries to attack it and try to create a doubt in the jury's mind as to whether or not it in fact is the blood that it's alleged to be.
Well, the DNA evidence, assuming for a moment that the DNA evidence is favorable to the prosecution, they of course put it into evidence. The mere fact that it's put into evidence creates a prima facie case, in twofold case. Number one, there is a probability or a possibility that Mr. Simpson or an individual with his genetic makeup was at the scene. But number two, there is a percentage of error ranging from 2 to 5%, depending upon the kind of test, that he may not have been the individual. So it creates, inherently, it's a paradox.
And when the burden of proof is beyond a reasonable doubt,
that's where your percentage maybe gets you over or underneath that burden. In the case of the defense, looking for, of course, an acquittal.
Now, we're talking about the OJ case on this show because it's what's in the news. Every day it's been in the news for months and months. Tremendous amount of pretrial publicity. Joe, can you get a fair trial?
In my belief, from my experience, he cannot get a fair trial in the continental United States. It's my opinion and opinion of other people, even in law enforcement. Everyone in the civilized world has an opinion on the OJ Simpson case. I don't see how a jury can be selected. I praise the attorneys that are doing the jury selection. They're working very hard. The jurors themselves should get praised because they have to throw out everything they've learned, all the prejudices they've had since infancy, all feelings, all opinions, everything they've read and heard, and they've got to make their minds blank. So I frankly don't see how the man can get a fair trial. It's been decided in the press.
Now, Joe, you mentioned opinions, and as a retired New York City detective who worked on murder cases here in New York City, who was involved in the prosecution of alleged murderers, give us your opinion about what you've seen and what you've read, the quality of the work of the detectives out in California. Are they doing a good job?
Well, not having privy to any evidence gathered and not having privy to their notes or anyone who has seen their notes, I honestly don't know. I know how I would have investigated it, how I would have gathered evidence, who I would have led at the crime scene and not led at the crime scene.
What would you have done differently from what's been done out there so far, if anything?
Well, I would have had only police personnel at the crime scene. From videotapes on newscasts that I've seen non-police personnel to
Well, the prosecutor was there.
The prosecutor was there. I truly don't know if the prosecutor was there before or after the search warrant. If the prosecutor was there prior to the search warrant, that's an error.
Why?
Well, she's not a trained investigator. She's not a trained evidence gatherer. And if the attorneys so choose, because she was there prior to the search warrant, they can call her as a witness.
Wouldn't that create a conflict with her being a prosecutor as well as a witness?
Certainly would.
Wouldn't that disqualify her as a prosecutor?
Yes. So being the learned person she is, I could assume that she was there after the search warrant was issued as the overseeing prosecutor. But I personally don't know. And I don't think it's been in the press either.
Now, we've also been able to watch almost on a daily basis as there are proceedings, the suppression proceedings in the trial. Watch what goes on TV in the courtroom every day. There is a camera in the courtroom in California allowing the American public to watch the trial. Cameras in the courtroom. Frank, is it a good idea? Should we have them in New York?
I'll tell you, Sandy, at this moment, it has its good points and its bad points. Like anything else that's in its infancy, I think the problem stems from the fact that right now, all parties involved, including the judge, the court, I think they're very cautious with how they speak. They're very cautious with the decisions they make. And I think you noticed, even the way today's decision, Lancito, again, he's delaying. I think right now everybody's concerned about how, as individuals, they're coming out here. And I think that tends to play into the outcome, or at least procedurally tends to play into the way each party and each side goes about handling this case.
Frank,
and that's dangerous.
Let's put you in the shoes of the defense, and Joe, let's make you the prosecutor. What kind of juror would you want if you were defense counsel? And then Joe, what kind of juror would you want if you were the prosecutor? Let's start with the defense.
Well, in the jury selection, of course, everybody is, again, there's posturing that goes on there too. It's a tremendous, if not always, or very often, the deciding part of a trial, especially a criminal trial. In the case of the defense here, you're looking for, of course, a liberal jury. You're trying to stay away from a conservative approach to the case.
What type of people would you be
I'm looking for younger people that are more in tune to current events. I'm not so certain that I want people that have stayed away from current events. I want people with an open mind, people that don't take all this fanfare and all this posturing at face value and are willing to listen during the course of a trial to each and everything that the defense has to say.
What about race? Would you be looking for one particular race?
I'm not so concerned about it. I'm really not so concerned about race. I think OJ Simpson, as an individual, I think he appealed to millions of Americans, irrespective of their race. And I think that'll be reflected in how people now view him. He is a defendant. He's faced with serious charges. The crime of itself is a heinous crime. Somebody did it. And I think the people are willing to give him his fair shake. And I just hope that race isn't a factor. And I personally don't think that in picking the jury, you even have to make that a consideration.
Joe, you're the prosecutor. Who do you want on your jury?
Well, I would want conservative people, preferably people that grew up in a small town, people that have old-fashioned values, possibly that haven't been exposed to the media and the new modern world of the 90s, because the prosecution naturally believes that the man is guilty, and he wants to take what evidence that he does have and present it to a jury who may or may not be sophisticated enough to question that evidence and result in a conviction. So I want ultra-conservative, possibly blue-collar workers, small-town people with old-fashioned values, not necessarily young, up-and-coming Americans who are cosmopolitan.
Now, this trial has come up very quickly. From your experience as a detective in homicide cases, the cases come up this fast for trial?
I've worked on 4 homicide cases in Brooklyn while I was a detective in Brooklyn for 5 years there. And we never had a case come up that quick. As a matter of fact, with a known perp in one trial, it took approximately a year and a half before it ever hit the courtroom.
What's the reason? Why is this case being tried so quickly?
Well, being a former cop, I'm prone to be slightly cynical. I believe that everybody is using the unfortunate circumstance of the homicide that did occur as a stepping stone to bigger and better things in their own personal life. That's my opinion. The newspaper reporters are using it to get a name for themselves on how terrific they are. The prosecution naturally does a good job. The prosecution goes up. Defense, well, he speaks for himself. He's a noted lawyer already.
Well, it's not just one, it's a team. I mean, you have
Right.
Johnny Cochran trying the case. You have a team of perhaps the best, most competent, most well-known criminal lawyers in the country on this case.
It's a stepping stone. Some people, I would venture to say all the people that are involved truly believe they're doing the right thing, but they're human beings also, and that's why the trial came up. Everybody jumped on the bandwagon.
Now, we talk about evidence and the type of evidence in this case. So far, it's all circumstantial.
Correct.
Can someone be convicted on circumstantial evidence?
Absolutely. But like in any other trial, the more circumstantial evidence, the better. You don't have any material witness here, obviously. You don't have a confession here. The case is going to hinge on circumstantial evidence. That's what makes the DNA such a big factor, because the DNA, being a scientific piece of circumstantial evidence, is probably the most devastating because it can be the most accurate. The foundation for the DNA does not have to be laid like it has to be laid for the glove or any other bit of circumstantial evidence that comes in. There has to be a trail, a foundation laid, a trail, an authentication, a chain of custody and control of the evidence as you continue throughout the pretrial procedure. So the prosecution has its hands full with most of the circumstantial evidence.
I'm going to ask the million-dollar question, but it's not going to be, did he do it? It's going to be, do you think he's going to be convicted? Joe, what do you think?
It's difficult to say. Some people may disagree with me. My own opinion is that based on the evidence that I have knowledge of, that I know about, and that I've digested and discussed with other people in the profession, I don't believe he'll be convicted on that evidence alone.
Why?
It's circumstantial, including the DNA, as Frank so aptly pointed out. There's a 2 to 5% margin of error. a 2 to 5% margin of error is the exact numbers that people argue against capital punishment. So if the lawmakers and the citizens of the United States say you can't have capital punishment because even if he's convicted, there's a 2 or 5%
Well, the issue
error.
of capital punishment is out of it. Because
Well, I understand
made
that,
determination,
but
which
the
was a
analogy-
strategy in the case.
But the analogy is there. If you don't want capital punishment because there's a 2 to 5% error that you might have the wrong man, how can you convict a person exclusively on DNA with a 2 to 5% error?
Now, let's go back to that first question, which I didn't ask you then. I'm going to ask you now, because I know you have an interesting theory with regard to what really happened. What do you think really happened at that crime scene?
Well, I believe, based on experience that I have had, there was more than one perpetrator.
So it's your theory that if O.J. Simpson, do you think O.J. Simpson was one of the perpetrators?
He may have been one of them. If he was the perpetrator, my opinion, based on the evidence that I know of, again, it's always based on the evidence that is available to us, he was not alone.
Why do you think he wasn't alone?
There were two victims. Two victims had to be extremely agitated. We know of, when I say we, I mean the American public knows of no evidence that says either one of them were taken from behind, thus eliminating one person immediately. So based on the viciousness of the crime, the mutilation of the crime, how quickly it evidently was done, I would say that the killer had an assistant.
Do you agree?
I tend to agree with Detective DeCicco.
Why?
I think the bottom line is that Mr. Simpson, if in fact he was a co-conspirator or a conspirator in the case, he was not alone. The crime was much too heinous, much too gory, and took, I would say, much too long a period of time for one individual to have been as successful, as brutally successful as this one individual was, if there was one individual, to be able to murder two well-fit, relatively young, capable individuals, capable of defending themselves, capable of fleeing the scene, capable of making some sort of ruckus to alert any passerby or alert anybody that this situation was happening.
Now, I asked the opinion of the police detective. Now, let me ask you, do you think he's going to be convicted?
No. If today the jury was sequestered, I would say no.
Why?
Too many unanswered questions. I think one of them is the question that we're posing now. The logistical problems, the physical problems with the one killer theory. I think other questions, the DNA problem. I think the prosecution is putting itself in the public eye anyway, in the eye of anybody watching this. They're putting themselves in a corner with this delay. I think they're creating uncertainties.
You're trying the case for the defense. Would you put O.J. on the stand?
Absolutely. Everybody wants to hear from O.J. Simpson. If he doesn't take the stand, the one question everybody will have is, what is he hiding?
Do you think he's going to take the stand?
If asked by his attorney?
Well, do you think his attorney's going to ask him? Do you think the strategy is going to put him on?
I'm not a lawyer. If I was the lawyer defending the man, I would definitely put him on.
Well, you're more experienced in the prosecution as a detective because you worked with the prosecutors in working the cases up. As a prosecutor, do you think you'd want the opportunity to cross-examine him?
In most instances, it's a prosecutor's, I won't call it a trick because it's not a trick, it's overt, it's right up front. It's to a prosecutor's benefit to put a defendant on the stand if his attorney will allow it.
I mean, if I was sitting there as the prosecutor and the defense made the decision to call him, would I say, great, or would I say, uh-oh?
If the defense called his own client,
in this case,
as a prosecutor, I'd be elated because that opens up a lot of avenues that he as the prosecutor cannot open.
Now, of course, not only does O.J. not have to take the stand, I'm sure the defense counsel will and the judge will properly prepare the jury that if he doesn't take the stand, it can't be held against him. Whether it will be or not, we'll never know, because we don't know what goes through a juror's mind.
That's correct. The judge will caution them it can't be held against them, but that's the same thing as saying the jury will disregard that last remark. It's already out.
If he takes the stand, what kind of witness do you think he's going to make?
Okay. I think he'll make a good witness, and I'll tell you why. Most of the problems, Andy, with defendants taking or not taking the stand, hinge upon their past or their either prior criminal history or prior any prior maliciousness.
I mean, the man's an actor.
The man is not only an actor, he's an American hero. He has no prior record. He has no prior criminal record. His history is nothing but good.
What about that family court stuff where
I don't. Okay, the family court stuff, I think, is not as damaging as it seems now, because hindsight is 20/20. He may have had some problems with Nicole Simpson. I think maybe 50% of the married American public has the kind of problems he's got. Of course, they've been made public now because of this incident, and everybody now is going back, in hindsight, like I said, is 20/20, and looking and saying, gee, we should have known then, or what a brutal guy this guy is. I don't think that the concerned, intense juror is going to take that approach, because that juror knows, he or she knows, that those specific incidents are past incidents that have no bearing upon this specific incident. If in fact Mr. Simpson did do it or didn't do it, they've got to take him at face value, and they've got to take him at what he says and make their own decision on his credibility. But at least he doesn't have to worry about any past problems which the prosecution could use against him, as it could against any defendant who has a past history of crimes.
We did a show a few months ago, and Barry Slotnick, a very fine criminal defense counsel, was here, and the OJ case had just started up. And at that time, he made a prediction, it's my recollection he made this prediction, that the case would never go to verdict, that there was going to be a deal cut somewhere before the final verdict. A few months have passed, a lot of evidence is out, a lot more has happened. What do you think, either of you? Do you think we're going to see a verdict in this case, guilty or not guilty, or there's going to be a plea at some point?
I can't see a deal made. I can't see what kind of a deal could the prosecution offer for a double murder, and what kind of a deal could Mr. Simpson take that would not keep him in jail for less than 15 years. I think this is an all-or-nothing case for both sides.
Joe, you've seen deals made, I'm sure, at the last minute.
Absolutely.
In plenty of cases where you're a detective and you
Yes.
probably weren't happy about some of them, and some of them maybe you said, well, great, at least the guy's behind bars. What do you think?
I don't think any deal will be made in this case. That's one of the reasons I feel there can't be a fair trial. Everybody has an opinion. Everybody's being watched, and as Frank so aptly put it, the cameras in the courtroom take away the concentration, the candor, the pure sense from the judges and the prosecutor and everybody to deal strictly with the facts. They're second-guessing themselves on tomorrow's tabloid report of what they did in the newspaper the day before. So they won't allow a plea. And Simpson is still professing his complete innocence. If I was innocent, I want a trial. I would not want to plead to anything.
But look what he's facing. I mean, you know the criminal justice system has certain balances, and one of those is that even though one may not be guilty and there's evidence against them that's there, and there's a risk they might be convicted, the opportunity to take a plea might be availed by someone because the result would be something they know as opposed to the unknown of a jury verdict and the kind of sentence one might get.
Well, again, I'm very happy I'm not in his shoes. And if I was, I would fight to the end. If I'm innocent, I'm innocent. And I would not plead.
Let's talk about the steps in the trial, what we have to look forward to in the trial, since I think it's both of your opinion that we're going to have a trial to the verdict. And then, of course, the appeals, depending on what happens with regard to the verdict. What are the steps after jury selection? What happens?
After jury selection, you go right into the trial. You have the opening remarks. In this case, the opening remarks are probably going to be very lengthy. Each side basically puts an introductory paragraph forward to the jury and tells the jury what they're about to see, what each side is going to prove, the kind of witnesses are going to be called, and what in effect the result should be. And then, of course, you go right into your witness calling. You go right into your testimony, eliciting testimony, expert or otherwise. You
know, as we're talking about going to testimony, do you think that all the evidence is out in this case already? What do you think as a detective? You think all the evidence is out there already, or that we're going to be surprised during the trial? We're going to see some surprises?
You mean out to the public?
Yeah, yeah.
It would be to the detriment of the Los Angeles Police Department and the prosecutor if it was all out there.
So you think we're going to see some surprises during the trial?
Maybe not surprises, nothing that people haven't guessed at, but as I say, I have no knowledge of it. And I said before, I had no privy to any reports. No one has seen the written reports. Everything is leaks and tangible evidence that was allowed to go to the press. It's not good procedural being from the prosecution or the police department to put everything out. And if anyone does that, they should all be retrained.
Let's continue with the trial.
Okay.
You were talking about the evidentiary portion, direct.
All right.
cross.
I think you're going to have a lot of, they're going to be introducing evidence on a piece-by-piece basis. You're going to have a lot of bickering back and forth in terms of the introduction of evidence, the admissibility of each bit of evidence. You're going to have a retracing of the steps of any piece of tangible evidence. The defense is going to challenge the authenticity, challenge the police handling of the evidence, the safeguarding, the custody and control. You're going to have witnesses getting on the stand solely to establish a chain of custody for every bit of evidence that was handled.
It's going to be a lengthy trial. How long is this
Absolutely.
trial
It's
going
going to be
take?
very tedious. This trial could take months, and God knows what the deliberation is going to take. It's going to be a while.
Okay, the evidence is in. What comes next? By the way, cross-examination, do you think that's going to be very important in this case?
Tremendously important. Cross-examination is the only means by which you get to discredit the opposition's witness.
What kind of reputation does Johnny Cochran have as a trial lawyer?
Tremendous trial attorney, tremendous cross-examiner. I mean, you hit the nail on the head with that word. That's why he's there. Johnny Cochran's there because he's the guy that's going to be telling or asking Mark Furman about his past problems. He's going to be the guy going to be asking the other detectives on the case for a step-by-step analysis of what they did, and you can be guaranteed that with each answer is going to become another question, another brain teaser, another obstacle to them putting the puzzle together, to the prosecution building a connected, lengthy sequence, connected, lengthy
By the way, I
story.
asked you before about the detectives
Yes.
in the case. What about the prosecution? What kind of job do you think the prosecution has done so far? I mean, you've worked with prosecutors here in New York.
I've worked with prosecutors. A quick opinion, I would say that she did a fairly good job. I'll go back to a statement I made a short time ago. It was, to me, a gross tactical error to be photographed, to even have gone to that scene and paraded around that crime scene. If the prosecutor wanted to witness evidence being gathered to make sure that the police department didn't mismark it, mishandle it, hand it off to somebody who didn't record it, like they did in the case where the Jewish boy was killed in Crown Heights. That was errors with police handling. If she chose to be there to make sure that there were no errors, it should have been after the warrant. The way it looked to me on television, she just had a merry old time walking around, and I believe that was an error. That was her only error that I have seen to date.
And on that note, we just about run out of time. I'd like to thank Joe DeCicco, retired New York City detective, Frank Angemi from the law firm of Angemi and Angemi, for appearing on Lawyers Corner, and good night, New York.
Thank you, sir.
Mr. Waters is coming. Absolutely gorgeous. It was so much fun.